Здравствуйте, дамы и господа. Продолжаем наши вебинары. И сегодня мы говорим о теме, к которой мы возвращаемся за последние 2 года в 3-й раз. Собственно, да, нашим основным докладчиком сегодня является Аня Кошебок, юрист английского права, наш сотрудник. И мы в 3-й раз именно с ней говорим по этой теме, потому что 1-й раз мы говорили в сентябре 2013 года о том, что, возможно, это законодательство будет меняться. Затем мы говорили в феврале 2014 года, что уже есть проект закона билл. И вот 26 марта... Нет, когда был принят этот закон? 25 марта 2015 года был принят закон об изменениях UK Companies Act. Закон об изменениях в корпоративном законодательстве Великобритании. Вот мне пора уже передавать слово Анику, вот я уже сбиваюсь, поэтому она сегодня как раз расскажет о тех изменениях, которые там предусмотрены этим законом, а точнее об одном главном изменении, которое, собственно, всех больше всего и пугает. Now I will switch to English. Well, but anyway, you will have both Russian and English transcript when this presentation will be translated into Russian.
Good morning, good afternoon already. So yes, a topic which we have touched upon a few times already in the past year and a half, very much awaited. Law came into force, or coming into force soon. About the register of people with significant control in the UK. You might have heard another phrase in this respect, more like the public register of beneficial owners, which the UK has promised to set up about 2 years ago.
So yes, always we were talking about the public register of beneficial owners. Now the term is changed. It is not the beneficial owners, but the
people with significant control. The change of terminology is the result of the will of the legislator to make the definition wider. Then generally the beneficial owner definition is how we know it in different kind of jurisdictions, in different legislations like KYC legislations in the world. So we have to get to know a new definition, people with significant control. So what this new registry will have in it is the information on these people with significant control of UK companies.
How these people are determined?
Just one point, we switch to the definition. Very important point is that the new law is changing the Companies Act of the UK. So it only affects UK limited companies at the moment. So those who have LLPs, they are not affected yet.
But geographically, it covers UK, Wales, Scotland.
Yes.
And Northern Ireland.
Not Ireland, no. Whether LLP will be brought under this legislation later or not, this is not yet known. We have not heard anything from the government, but it might be that it happened that it's only because they have not time. Since the general elections are going on in the UK at the moment, the Act received royal consent 2 days before the current Parliament stopped working.
I see. But coming back to LLPs, it seems that the intention of the legislator was to cover all the legal entities, and it is only by chance or by the first step these new changes are only limited liability companies by shares are covered.
Limited companies.
A limited company also by guarantee and others.
No policy has been made public yet whether the LLPs anytime soon will be covered. The main thing is to note that at the moment it's only limited companies. So who is the person with significant control of a UK limited company? The threshold of the definition is 25%. Different jurisdictions, for different purposes, beneficial owner might be defined as a 10% holder of interest. For the purposes of this register is 25%. The person who is holding 25% of the shareholding of the company, 25% of the voting rights, or 25% interest in receiving dividend distributions, or a person who is having the power to appoint or remove the majority of the board of directors if the company has a board of directors. The definition is trying to catch all, so there is a broader test which is not so exact as the 25% test, which says that an individual who influences and controls significantly the company. What this term exactly means, it still have to be filled with content. The government promises a guidance by October 2015, where they will give more content, more substance to this term, significant influence and control. They actually mean.
This is the guideline, and when the act will be implemented?
Yes, it's a very important question. Everybody asks, so when all this starts? The Act itself covers several areas, several changes in the Companies Act. As far as the register with people with significant control is concerned, is coming into force on 1st of January 2016. That's when the companies will have to set up their registers. The first time they will have to provide this information to the Companies House is April 2016. So the beginning of next year. Certain points are not yet clear. We will see them as we go along with this presentation. So a few guidances are still due from the government in October 2015, leaving not too much time for the companies to prepare completely to this new regime. That's why we are holding this webinar to warn everybody as early as possible that this obligation is coming, although not all details are known yet.
If we are talking about the obligation, we should talk about the responsibility and the subjects of responsibility. Who are those people?
So it is a UK company who is obliged to take reasonable steps.
So the first liable is the company
itself to set up this public registry of people with significant control. It is the company itself and the people who can act on behalf of the company, namely mainly the director, and also the actual person with significant control who is liable to provide the information which is required from him. So what steps the companies are expected to take? Companies will have to try to identify and contact the person who they believe is person with significant control. For single ownership companies, with small companies, it might be a relatively easy task because people, the director, the shareholders, and the people with significant control themselves, they are aware who these are. It might be a bit more difficult task for larger companies. So once a person is identified or suspected to be, let's call him the PCS, the person with significant control, the company would have to contact this person and ask for the relevant information which is to be held on the register, or provide him with the information which they already hold and ask this person to confirm that this information is correct and confirm that he is aware that he is deemed to be a PCS and he is aware that this information on him will be kept public.
Means the company should receive his written declaration,
confirmation that the details are correct and he is a person with significant control and he is aware that it's a public information or will be public information. The information which is held on these persons is their name, their residential address, their service address if it's different, country of residence, nationality, if more than one nationality, and all of it, date of birth, a date when this person becomes a person with significant control, and the nature of the control he has over the company. So under what point of that definition he falls under the person with significant control. If this if there is change in any of this information, then the register will have to be obviously updated, or if the person ceases to be a person with significant control, also. The person who is not complying with his duties in connection with setting up this register can be receiving in terms prison term or fine, or both. Probably I should have mentioned it in the other way around. It's probably the first step of consequences would be receiving fine. It can be on behalf of the company itself or the director. What the company can do if this person with significant control doesn't comply with the request, the company, the director acting on behalf of the company, suspects or identifies that this person might be a person with significant control, sends him a request for information or confirmation, but it doesn't receive any answer. In this case, the company can issue a warning notice to this person and give 1 month to comply. If there is still no action, the company may issue a restriction notice. A restriction notice would greatly limit the powers and the rights which can be exercised with respect to the interest that this person with significant control holds in the company. For example, any transfer of this interest would be a void transaction. No rights would be exercisable with respect of this interest. And most of all, a very severe consequence, there is no payment of any sums due from the company with respect to this interest may be paid out, meaning most of all dividends. The only form of money transaction which can take place with respect to this interest is payment of liquidation proceeds. So if the company is then decided to be liquidated, then this person may receive the liquidation proceeds.
So coming back to the dates, so if this new rule comes into force 1st of January 2016, then 3 months for letting know about that now it is needed to submit a significant PCS registers. Then 1 month warning period. That means first.
No, it's not exactly like that. The April 2016 is the date when these companies first have to submit the confirmation statement, which we will talk about in a minute. What this is. A confirmation statement in which they already need to have all this information.
I see.
So this is why the companies have that 3 months to basically set up their register, because by April 2016 they will have to be able to already submit a new submittable, so to speak, which is called confirmation statement, which takes over from the good old well-known annual return. Instead of annual return, companies will be obliged every year to submit a confirmation statement, and this, the information of people with significant control will be part of this confirmation statement. So in April, they already will have to be in the position to submit this information. This is why we advise companies to follow the news upon further guidances that come out in October, November. Think about their procedures, how they internally see this working, and in January already be able to send out requests and act actively, because they soon after they will have to have.
So February 1st warning letter, March restriction.
Restriction.
I see. So it is 1 month and a half after vacation period for Russians, for their companies to be blocked, restricted.
It will be an interesting question to see how it in practice will work for for small companies which have one shareholder, one beneficial owner, one director, because we see that it's kind of a family matter. So how a director who might be a trusted friend of a shareholder would restrict a non-compliant shareholder's rights or beneficiary's rights. But hopefully it does not get to that, and a beneficial owner or a person with significant control of such company would not bring the director into such situation.
I see. And the most interesting, how the counterparts will act and will follow this law, especially if these counterparts are, for example, banks, non-UK banks, say European banks, how they follow the UK law. Whether they will request these PCS registers and whether they block the accounts or well.
Yes, this is yet to be seen. Whether foreign entities like service providers, it can be trust companies, lawyers, or banks, probably banks most importantly, whether they will introduce this register as part of the KYC requirement for UK companies. If requiring it next to their certificate of incorporation and other registers, whether they will ask for this third register, it is yet to be seen, but they would have the right to do so if they decide, if the internal compliance policy takes them that way. And that takes us to the question that who is going to have right to inspect, who is going to have right to access the information which is held in this register. To start with, as a starting point, where would this register be kept? The register can be kept by the company, as we so far have talked about it. The company may decide that the register is kept at its registered address or at another address, but nevertheless in the UK. To be more precise, in England and Wales. And they will have to report it to the company's house where this address is. So the company's house would need to be aware where this register is kept. If the legislation gives a choice to the company to choose and to opt for the company's house to keep this register. In this case, the company is obliged to provide the information necessary for the setting up of the register to the company's house, but the company's house would electronically hold this register instead of the company. In this case, any third party who would want to access the register would receive the information from the company that no, my register is with the company's house. So the register is located either with the company or the company's house. If the company holds the register and the third party makes a request that he wants to access this information, the company unfortunately has to oblige and has to give this information to that third party. If that third party has a proper purpose why he's asking for it, has to give this information out within 5 days of receiving the request. If the company believes that the request is not proper, it's not based on a proper basis, they may turn to a court and explain why they declined to comply with the process.
So the main issue is what is
proper purpose. It is. It seems that the court cases will fill it with substance, that what proper purpose is, but it's highly likely that that causes other than serious risk of violence or intimidation of the person with significant control or the company would result in denial, in a just denial of the request. So there will be very limited cases where the company will be in a position to decline this request. And unfortunately, the legislator puts a huge burden on the companies because they cannot just say no. They have to go to the court and argue that the purpose is not proper. They do not want to comply with this request. If the company just doesn't do anything, doesn't give out the information, and doesn't go to the court, then it will be they will be subject to fine, the company itself and the every officer who is liable in the company for these actions. It will be a default fine at the start with, and then a daily fine until the request is either complied with or successfully prevented by court. Mm-hmm. So not acting out is not going to be an option. Looking at the other choice, where the register is held by the company's house, it is not yet known, it has not been published, that on what basis and to whom this information will be available or given out by the company's house. Again, a guidance by October 2015 is promised, which will set out that on what basis, for how much money, within what sort of time, the company's house will give out this information and to whom.
So the public register may not be for public.
This is,
fortunately,
but not completely public as it seems right now. We will see what will be in that guidance. It seems right now that it's not that it will be published in a newspaper.
At least.
At least. Just a further note, the company will also have the option to keep not only the register of person with significant control, but also the register of directors and shareholders with the company's house and not by the company itself. I believe that the most problematic point in this rule is, generally the rule seems to be wanting to push the companies towards the option to keep the register with the company's house, because of the administrative burden and the risk that it poses to the company. 5 days is a very short period of time for a small company or a company which doesn't have proper representation in the UK but works through service providers, would physically not receive a request within 5 days, in my opinion, if post would have to be forwarded to a foreign country. So would very easily fall into default without the intention of doing so. So with the best intent, they might still receive some fines just because of the time limitation. So the 5 days and that the only recourse is going to the court is very restrictive. So we're very interested to see the exact procedure of the company's house to hold this register.
So massive, dramatic changes are expected.
Which, yes, expected, and it's yet to be seen how the courts will cope with this. There will be probably a huge workload on them as a consequence. How company's house is going to proceed with the workload which this new law puts on them. Last year, when there were still just talks within the sector, financial sector, about this proposal, when it was just still a proposal, there were jokes that even the UK cannot anticipate how much time and money it will take them to actually implement this. When the whole proposal came out, the UK was very adamant that they would force, or at least try to push, their overseas territories also in the direction of implementing something of similar sort. Overseas territories meaning mostly the offshore jurisdictions like the BVI or Cayman Islands. But we may say, luckily, these offshore territories said that they are not ready and they do not see the positive effect of implementing a legislation like this, which would put a huge administrative power on their financial sector. Let's not to forget that over in the offshore jurisdictions, registered agents take a huge role in the lives of companies. So it would put a huge burden on their financial sector without the evident upside, because they believe that the current KYC legislation of these overseas territories, and pretty much I believe in any EU countries, serve exactly the same purpose and give less opportunity to abuse the system. Because under this legislation, any third party may turn to the company for information and maybe pretending some purpose which seemed to be proper, but with some ulterior motives, they can receive information that otherwise should be kept confidential.
Okay, so this is definitely not the last time when we are coming to this topic. I suppose the next time we may come when the guidelines
further guidances are available.
Yes. Yes. What are the most interesting topics which should be disclosed? Is what is proper request?
What is proper proper purpose?
Proper purpose, yeah.
And the actual the company's houses procedure in keeping and disclosing information.
I see. Okay, so таким образом будем обращаться к этой теме еще неоднократно, даже в течение этого года. А на сегодняшний момент спасибо большое. До новых встреч. До свидания.